Hello, my name is Scott Spivey, and I currently represent past and present members of the Coast Guard, Coast Guard Auxiliary, and Coast Guard Reserve that were injured during the BP spill. Frequently, I'm asked whether or not a service member can even bring a claim against BP. So I've prepared the following summary. Lieutenant J.G. Doe versus BP. Is the claim barred by what's known as the Ferris Doctrine? As most service members know, generally if not by name, under the Ferris Doctrine, military members are barred from bringing suit against the U.S. for injuries that arise out of or are in the course of activity incident to service. The Ferris Doctrine originally only applied when the service member was injured by another service member. Later, it was expanded to encompass the civilian employee of the government. And some government contractors have even asserted that it should be further expanded to include intramilitary immunity for some contractors. The Ferris Doctrine spawned from the United States government's passage of the Federal Tort Claims Act, the FTCA, in 1946, which was intended to be a broad waiver of the government's sovereign immunity. The Ferris Doctrine was an exception to that rule. But does this apply to BP? Our position is no. BP is neither the federal government nor a military contractor under these circumstances. BP is the bad actor or tortfeasor. Now, every state has their own standards for tort liability or negligence. In Louisiana, we're governed by the Louisiana Civil Code for these. Civil Code Article 2315 provides in part, every act whatever of man that causes damage to another obliges him by whose fault it happened to repair it. Article 2316 provides, every person is responsible for the damage he occasions, not merely by his act, but also by his negligence, his imprudence, or want of skill. Generally, negligence refers to a defendant's conduct, which falls below a legal standard established to protect others against unreasonable risks of harm. The standard is based on a defendant choosing the reasonable alternative when the harm occurred, the reasonable man standard. In Louisiana, the courts generally use the duty-risk analysis approach to determine the liability of a defendant in a tort action for negligence. In order for the defendant to be liable for negligence, the court must find that the defendant met all of the following elements: cause and fact, duty, scope of protection, breach of duty, and damages. And even if you don't live in Louisiana, you may still be covered under Louisiana law because of where the spill occurred and where the cleanup occurred. Okay, so that's a lot of legal mumbo jumbo, but what it means is that an entity is liable for the damages that it causes when it has a duty to protect the person injured from those injuries, it breaches those duties, and the person is damaged. So, if Lieutenant Junior Grade suffers from neurological injuries or damages that are in fact caused as a result, indirect or otherwise, of her being exposed to a hazardous chemical to clean up the spill caused by BP, it's our position that BP is liable. However, many have questioned whether the intervening act of the Coast Guard in employing the spill and choosing the dispersant somehow absolves BP of liability. No, we don't think so. While the Coast Guard and U.S. government may not be liable under the Federal Tort Claims Act pursuant to the Ferris Doctrine, and thus BP arguably cannot bring in the Coast Guard or the U.S. government into the suit through what is known as a third-party claim, arguing that the Coast Guard chose the dispersant, that does not preclude the LTJG's suit against BP. And what we're actually pursuing is not a claim in federal court pursuant to a lawsuit at all. The BP Settlement Fund, that is the Deepwater Horizon Medical Benefits Class Action Settlement Agreement as amended on May 1st, 2012, states that responders are entitled to seek compensation for medical claims. In this document, and I quote, response activities shall mean the cleanup, remediation efforts, and all other responsive actions, including the use of handling of dispersants, related to the release of oil, other hydrocarbons, and other substances from the MC-252 well and or the Deepwater Horizon and its appurtenances that were done under the auspices of the Unified Command, BP, or a federal, state, or local authority. Lieutenant J.G. Doe versus BP. Is the claim barred by the Ferris Doctrine? The short answer is no.